Case 1. Danielle Dauphiné. Rockingham County, State of New Hampshire. Between September 21st and September 24th, 2021. Discovery date: October 23rd, 2021. There are moments in the history of a community when everything that seemed ordinary is suddenly replaced by something that cannot be explained or easily accepted. In Derry, New Hampshire, a town in Rockingham County that most residents would describe as quiet, familiar, and safe, one of those moments arrived in the autumn of 2021. It arrived not with a dramatic public event, not with a scene that unfolded in the open, but with the quiet, devastating absence of a 5-year-old boy named Elijah Lewis. Derry is a town of roughly 33,000 residents. It sits in the southeastern corner of New Hampshire, close to the Massachusetts border, and it carries the character of a community that has grown steadily over the decades while retaining the small-town familiarity that defines much of the Granite State's residential landscape. People in Derry know their neighbors. They notice when something is wrong. They pay attention to the children who move through the streets and the parks and the schools that make up the fabric of daily life. And in October of 2021, it was that attention, that communal awareness, that finally set in motion the events that would bring the truth about Elijah Lewis to light. Elijah Lewis had been part of the fabric of his small community. He had attended kindergarten. People who encountered him described a child with energy and curiosity, the qualities that belong to 5-year-olds who are discovering the world around them and testing its boundaries with the enthusiasm that only early childhood produces. He had a smile that appeared in the photographs that would later circulate widely across New Hampshire and beyond. He was, by every account, exactly what a 5-year-old child is supposed to be. He was alive in the way that children are alive, completely, immediately, without reservation. To understand what happened to Elijah Lewis, it is necessary to understand the environment in which he was living in the final months of his life. Danielle Dauphiné, his mother, had a history that had drawn the attention of child welfare authorities before the events of 2021. That history, documented in the records of the New Hampshire Division for Children, Youth and Families, reflected a pattern of instability that child welfare professionals are trained to identify as a risk factor for the children in such households. Despite those documented concerns, despite the prior contacts between child welfare workers and the household, Elijah remained in Dauphiné's care and was living with her and her boyfriend, Joseph Stapp, in Derry when the events that would end his life occurred. In the weeks before October of 2021, Elijah had become invisible. He was not in school. He was not seen by neighbors. He was not taken to appointments or observed in any of the ordinary ways that children in functioning households are seen by the wider world. The people responsible for him, his mother, Danielle Dauphiné, and her boyfriend, Joseph Stapp, had allowed him to disappear from sight, and the world around them had not yet understood what that disappearance meant. The absence of a child from the visible life of a community is not always immediately recognized for what it is. Children disappear from view for many reasons: illness, family travel, changes in routine. The ordinary explanations that adults reach for first are not always wrong. But in Elijah's case, the absence extended long enough and was complete enough that the people around the household began to ask questions. Those questions produced no satisfactory answers. The concern grew, and eventually, it produced the call to law enforcement that started everything that followed. On October 14, 2021, a report reached the Derry Police Department. Elijah Lewis was missing. The report did not come from Dauphiné. It did not come from Stapp. It came from members of the community who had grown concerned, who had noticed the absence, who had asked questions that produced no satisfactory answers. When Derry officers made contact with Dauphiné and Stapp, the accounts they received were inconsistent. Neither adult provided information that explained where Elijah was or what had happened to him. The inconsistencies were not minor. They were the kind of inconsistencies that experienced law enforcement officers recognize as indicators that the truth being concealed is serious. Law enforcement responded with urgency. The New Hampshire Attorney General's Office, the New Hampshire State Police Major Crime Unit, and the Derry Police Department coordinated a search that extended beyond state lines. Investigators worked methodically, following every lead, pressing every avenue of inquiry available to them. They understood from early in the investigation that time was a variable they could not afford to ignore. They understood that the inconsistent accounts of Daphne and Stapp, combined with the complete absence of any credible information about Elijah's whereabouts, pointed toward an outcome that everyone involved hoped they would not find. The search was not brief. It involved coordination between multiple agencies across multiple jurisdictions. It required investigators to work long hours following threads of information that sometimes led nowhere and sometimes opened new directions. The New Hampshire Attorney General's office, which takes jurisdiction over homicide investigations in the state, committed its full resources to the search. The State Police Major Crime Unit brought its specialized investigative capabilities to bear. Every tool available to New Hampshire law enforcement was deployed in the effort to find Elijah Lewis. On October 23, 2021, investigators located Elijah Lewis. His remains were found in a state park in Abington, Massachusetts, approximately 1 hour from the Derry home where he had been living with Daphne and Stapp. He was 5 years old. The New Hampshire Medical Examiner's Office subsequently made findings regarding the manner and cause of his passing. Those findings reflected what investigators had feared from the early days of the search, that Elijah had not received the care a child requires to survive, and that the people responsible for providing that care had failed him in the most final way possible. The medical examiner's findings indicated that Elijah had been subjected to conditions of profound deprivation and neglect over an extended period, conditions that a 5-year-old child has no capacity to address or escape on his own. The distance between Derry, New Hampshire, and Abington, Massachusetts, was not incidental. It was a deliberate choice. Investigators determined that Daphne and Stapp had not simply failed to act when Elijah needed them. They had subsequently taken deliberate action to place his remains beyond the immediate reach of New Hampshire law enforcement. That determination, that the concealment was active and deliberate, not passive or accidental, was central to the witness tampering charge that would accompany the second-degree murder charge against Daphne. Danielle Daphne and Joseph Stapp were both taken into custody by New Hampshire law enforcement. Daphne was charged in Rockingham County with second-degree murder and witness tampering. The second-degree murder charge reflected the legal determination that she had acted knowingly, that her conduct had resulted in Elijah's passing, and that she had understood the nature of what she was doing. The witness tampering charge reflected something equally significant in the eyes of Rockingham County prosecutors. After Elijah was gone, Daphne had not sought help. She had not come forward. She had not called for emergency services or made any attempt to ensure that her son received the help a living child might still have needed. She had taken active steps to prevent law enforcement from finding her son and from learning what had happened to him. The investigation revealed the conditions in which Elijah had been living in the period before his passing. The picture that emerged through the court process was one of sustained neglect, a child who had been denied the basic provisions that sustain life, in an environment where the adults responsible for him had prioritized everything except his well-being. Investigators who reviewed the conditions of the household and the timeline of events described a situation that had deteriorated over an extended period and in which multiple opportunities to intervene had not been taken. It was a portrait of failure so complete and so prolonged that Rockingham County investigators and prosecutors described the case as among the most serious child welfare failures they had encountered in their professional experience. The legal proceedings that followed Daphne's arrest moved through the Rockingham County court system with the deliberateness that serious felony matters require. Her case was reviewed by prosecutors, presented to a grand jury, and formally indicted. The indictment set out in the specific language of New Hampshire criminal law the conduct for which the state of New Hampshire held Danielle Daphne responsible. It was a formal document, produced through a formal process, and it represented the considered judgment of the Rockingham County legal system that the evidence against Daphne was sufficient to bring the full force of the state's prosecutorial resources to bear. Daphne did not go to trial. In Rockingham County Superior Court, she entered guilty pleas to both second-degree murder and witness tampering. Her guilty plea was a formal admission before the court, an acknowledgement, in the language of the law, that she was responsible for what had happened to her son and for what she had done afterward to conceal it. The court accepted her pleas. At sentencing, victim impact statements were presented to the court by community members, advocates, and individuals who had known Elijah or who worked in child welfare and understood the significance of what had occurred. Those statements gave voice to the grief of a community that had lost a child it had not been able to protect. The sentence imposed reflected the gravity of both convictions. Dauphiné was committed to the New Hampshire state prison system for a substantial term. The witness tampering conviction carried an additional consecutive component, a deliberate choice by the court to treat the concealment of Elijah's passing as a distinct and serious act deserving of separate punishment. Not a footnote to the primary conviction, but a crime in its own right that extended and compounded the original harm. Joseph Stapp faced his own proceedings in Rockingham County in connection with Elijah's passing. The case prompted a significant and sustained conversation within New Hampshire about the systems designed to protect children. The New Hampshire Division for Children, Youth and Families, the state's primary child welfare agency, came under scrutiny. Questions were asked about prior contacts with the household, about what had been observed and recorded, and about whether different decisions at earlier points might have produced a different outcome for Elijah. Those questions are the right questions to ask, and New Hampshire's child welfare community engaged with them seriously in the months and years following the case. Reviews were conducted. Protocols were examined. The lessons of Elijah Lewis's case were absorbed into the training and practice of child welfare professionals across the state with the seriousness that his passing demanded. The broader community response to Elijah's case reflected something important about the society in which he had been living. The initial report to law enforcement had not come from official channels. It had come from ordinary people, neighbors, community members, individuals who paid attention and who refused to accept the absence of a child they had known as an ordinary or unremarkable fact. Those people, in taking the step of contacting law enforcement, did what the entire architecture of community child protection depends on individuals doing. They saw something. They said something. They made a call that set in motion the investigation that established the truth about what had happened to Elijah Lewis. That act, the act of noticing, of being unwilling to accept an unexplained absence, of making the call, is the act that every child protection advocate, every mandatory reporter trainer, every community education program about child safety tries to inspire in the people who go through it. In Elijah's case, it did not come in time to save him, but it came in time to find him, to establish the truth of what had happened to him, and to ensure that the people responsible face the accountability the law demands. Elijah Lewis deserved to grow up. He deserved the kindergarten classroom, the playground, the ordinary accumulation of years that children in safe homes take entirely for granted. He deserved the chance to discover what kind of person he was going to be. The Rockingham County Court that accepted Danielle Dauphiné's guilty plea and imposed her sentence did what courts are designed to do. It answered for what happened to him in the only language the law possesses. It was not enough to give Elijah back. Nothing could do that. But it was the answer the law could provide, and New Hampshire provided it fully, completely, and on the record. If you are concerned about the welfare of a child in your community, please contact the Child Help National Child Abuse Hotline at 1-800-4-A-CHILD. That is 1-800-422-4453. Trained counselors are available 24 hours a day, 7 days a week. A single phone call can change the outcome for a child who cannot advocate for themselves. Elijah Lewis was 5 years old. His name belongs to this record. It belongs to this documentary. And it belongs to the memory of everyone who believes that children deserve better than what he received. If this case has moved you, please take a moment right now to hit the like button. Your support keeps these stories alive and ensures that the people at the center of them are never forgotten. Case 2. Emily Long. Strafford County, State of New Hampshire. August 18, 2025. There are events that arrive without warning in communities that have given no indication of what is coming. There are tragedies that unfold behind closed doors, invisible to the neighbors and colleagues and friends who will later struggle to reconcile what they are told with the people they believe they knew. In Madbury, New Hampshire, a small town in Strafford County, the kind of community where residents know each other and where the rhythms of daily life have a familiar, steady quality. One of those tragedies arrived on August 18, 2025. Madbury sits in the southeastern corner of New Hampshire, a short distance from the city of Dover and from the University of New Hampshire campus in nearby Durham. It is not a place where residents expect to encounter the kind of event that Strafford County law enforcement documented that August morning. It is exactly the kind of place, quiet, residential, ordinary, where the discovery of what investigators found that day lands with the full, disorienting weight of the completely unexpected. On August 18, 2025, Strafford County authorities responded to a residence in Madbury. When officers arrived, they encountered a scene that required the immediate involvement of the New Hampshire Attorney General's Office, the New Hampshire State Police Major Crime Unit, and the New Hampshire Medical Examiner's Office. Inside the home, investigators found Ryan Long, Emily Long's husband. They found two of the couple's children, Parker Long and Ryan Long Jr. They found Emily Long herself. None of them had survived. The New Hampshire Medical Examiner examined all four individuals. The findings that followed were reported by the Associated Press and confirmed by New Hampshire law enforcement. Ryan Long, Parker Long, and Ryan Long Jr. had each lost their lives as a result of gunshot wounds. Their passings were ruled homicides. Emily Long had also lost her life to a gunshot wound. Her passing was ruled a suicide. Strafford County authorities, in coordination with the New Hampshire Attorney General's Office, officially classified the August 18th incident as a familicide, a term used by law enforcement and researchers to describe the specific and devastating category of event in which a family member causes the loss of multiple immediate family members before taking their own life. Familicide is among the most studied categories of event in contemporary criminology. It occurs across every demographic, every income level, every geographic and cultural context. Researchers who have devoted careers to understanding it consistently note the complexity of the factors involved and the difficulty of identifying reliable predictive indicators in advance. Law enforcement professionals who respond to these events describe them as among the most challenging they encounter, not because the investigative facts are typically unclear, but because the human context surrounding those facts resists simple explanation. What the official record in Strafford County reflects about August 18, 2025, is not simple. Ryan Long was a husband and a father. Parker Long and Ryan Long Jr. were children. They had lives, relationships, futures, and the daily texture of existence that belongs to people embedded in families and communities. The details of those lives, the specifics of who they were, and what they meant to the people who loved them, belong to those people. This documentary acknowledges their lives and honors them by stating clearly and on the record that they did not deserve what happened to them, and that New Hampshire's official institutions responded to their passing with the thoroughness it demanded. Because Emily Long did not survive the events of August 18th, the criminal justice process that follows when a perpetrator is living, the arrest, the charges, the court proceedings, the verdict, did not occur. What occurred instead was a thorough law enforcement investigation, the findings of which were documented, preserved, and made part of the official public record of Strafford County. Those findings were communicated to the public through official statements and through reporting by established news organizations. The record is complete even in the absence of a trial. The Long family resided in Madbury. They were part of a community. The loss of 3 of its members, a father and 2 children, on a summer morning in 2025 is a wound that the Madbury community will carry. Strafford County's thorough documentation of what occurred is the foundation on which any understanding of the events must rest. Mental health professionals who study familicide consistently emphasize the importance of crisis intervention, access to mental health support, and the willingness of communities to create environments where individuals experiencing severe distress can seek help without fear of judgment. Ryan Long, Parker Long, and Ryan Long Jr. are remembered. Strafford County, New Hampshire, made certain their passing was documented with the care the truth requires. Please hit the like button. Every subscriber helps this channel bring these important documented stories to a wider audience. Case 3 is next. Case 3, Danielle Kelson. Rockingham County Superior Court, State of New Hampshire. February 9, 2025. Arrest date, November 25, 2025. Exeter, New Hampshire, is the county seat of Rockingham County. It is one of New Hampshire's oldest and most historically significant communities, a place where the architecture of earlier centuries still shapes the streetscape, where civic life has deep roots, and where the institutions of local government and justice have operated in one form or another for generations. It is the kind of place where residents feel the particular security that comes from long-established community identity. It is the last kind of place where residents expect to learn that an elderly woman has lost her life inside her own home at the hands of someone she knew. On February 9, 2025, emergency responders were called to an apartment in Exeter. Inside, they found Janet Rishchil-Kelson. She was 88 years old. She was not alive. The New Hampshire medical examiner examined Janet Kelson and determined the manner and cause of her passing. The findings were unambiguous. Janet Kelson had not passed from natural causes. She had not experienced a medical event. She had suffered severe injuries to her head, injuries that the medical examiner determined were the result of an intentional act by another person. Janet Kelson's passing was ruled a homicide. Rockingham County investigators, working in coordination with the New Hampshire State Police, took charge of the investigation that followed. They worked methodically, documenting the scene, gathering forensic evidence, interviewing individuals with knowledge of Janet Kelson's life and circumstances, and building the picture that homicide investigations require. The investigation was careful and sustained. It extended across months. The Rockingham County Attorney's Office remained engaged throughout. What investigators found over the course of those months pointed toward a member of Janet Kelson's own family. Danielle Kelson was 55 years old. She was Janet Kelson's daughter-in-law, the wife of Janet's son. She was not a stranger to the victim. She was not an intruder or an unknown party. She was a person who had access to Janet Kelson's life through the ordinary channels of family relationship, through the accumulated proximity of years spent as part of the same extended household and family network. On November 25, 2025, Danielle Kelson was arrested by New Hampshire law enforcement. She was charged in Rockingham County with second-degree murder in connection with the passing of Janet Rishchil-Kelson. The charge of second-degree murder under New Hampshire law reflects a legal determination by Rockingham County prosecutors that the conduct alleged was deliberate, that Danielle Kelson acted knowingly in causing her mother-in-law's passing, and that the law's most serious homicide framework short of first-degree murder applied to what the evidence showed. Danielle Kelson was also charged with wiretapping and eavesdropping. That additional charge introduced a dimension to the case that extended beyond the events of February 9th. Investigators had determined that Kelson had engaged in unauthorized electronic surveillance, that she had recorded or monitored communications without legal authorization. The inclusion of that charge in the indictment reflected prosecutors' view that the case involved conduct that preceded the February incident and that demonstrated a pattern of deliberate, calculated behavior rather than a single impulsive act. The combination of charges, second-degree murder and wiretapping, painted a portrait for Rockingham County prosecutors of premeditation and deliberate action. That portrait was presented to a Rockingham County grand jury, which returned the indictment that authorized the arrest and prosecution of Danielle Kelson. At the time this documentary was produced, the case against Danielle Kelson was proceeding through Rockingham County Superior Court. She had not yet been tried. Under the foundational principle of the American legal system, she is presumed innocent unless and until the state of New Hampshire proves its case beyond a reasonable doubt before a jury of her peers or she enters a guilty plea. This documentary presents the verified facts of the case as established by the official public record, the charges, the investigative findings, and the medical examiner's determination regarding Janet Kelson's passing. Janet Rishchil-Kelson was 88 years old. She had lived a long life in New Hampshire. She had watched decades pass, had been part of a family, had accumulated the kind of personal history that 8 decades of living produces. She deserved to spend the final years of that life in peace and safety. She deserved the security that elderly individuals living in their own homes have every right to expect. She did not receive that security on February 9, 2025, and the Rockingham County criminal justice system responded to her passing with the full weight of its investigative and prosecutorial resources. The charging of Danielle Kelson also reflects something important about the protection of elderly residents under New Hampshire law. The criminal justice system's response to the passing of an 88-year-old woman in her own apartment, the months of investigation, the forensic work, the grand jury process, the formal indictment, is a statement that vulnerability does not reduce a victim's claim on justice. Age does not diminish the law's obligation to respond. Rockingham County made that statement clearly. As this case moves through the courts, the record will continue to develop. What is already established in that record is the passing of Janet Rischiel-Kelson, the manner in which the medical examiner determined she lost her life, and the formal charges brought by Rockingham County in response. The truth of February 9, 2025, in Exeter, New Hampshire, is preserved in that record permanently. Please take a moment to like this video. We are committed to bringing every one of these cases to you with the accuracy and respect they deserve. Case 4 is coming up, and it is one of the most extensively documented cases in Rockingham County history. Case 4, Sheila LaBarre. Rockingham County Superior Court, State of New Hampshire. 2005 through 2006. Conviction date, 2008. In the rural landscape of Epping, New Hampshire, there exists a category of criminal case that law enforcement professionals and criminologists describe as the most difficult to investigate, not because the facts, once uncovered, are unclear, but because the conditions under which the harm occurred were deliberately designed to prevent detection. The farm property owned by Sheila LaBarre in Rockingham County was one such environment. The investigation that ultimately brought the truth of what occurred there to the attention of New Hampshire's courts was one of the most complex and technically demanding in the state's history. The outcome, a conviction on 2 counts of first-degree homicide and a sentence of life without parole, stands as one of the most significant judicial outcomes Rockingham County has ever produced. Sheila LaBarre had been a resident of Epping for years before the events of 2005 and 2006. She owned a farm on a rural stretch of Rockingham County land. The property's isolation from neighbors and public observation was a feature of its geography that would later figure prominently in the prosecution's description of how LaBarre was able to operate as she did. The farm was not easily visible from public roads. It was not a place where the ordinary patterns of community life produced casual observers or uninvited witnesses. LaBarre had a documented history of interactions with law enforcement prior to the events that led to her arrest. That history, presented during the criminal proceedings, reflected a pattern of conduct involving men who were, in various ways, vulnerable. Individuals with limited support networks, developmental challenges, or personal circumstances that left them dependent on others and less able to advocate for themselves or to leave situations they might have recognized as harmful. Kenneth County was 24 years old. He had a developmental disability. He had come into LaBarre's life and ended up living at the Epping farm. His family was concerned about him. They had contacted New Hampshire authorities. Law enforcement had visited the property on a welfare check prior to the events that would ultimately result in LaBarre's arrest. Those visits did not produce the intervention that might have changed the outcome for Kenneth County. That fact, that law enforcement contact occurred and did not result in his protection, was one of the most significant and painful elements of the case as it unfolded in Rockingham County. Michael DeLogg had also been in a relationship with LaBarre and had lived at the farm. He was also young, also vulnerable, also without the support network that might have provided him with an alternative to the environment he found himself in. What happened to Kenneth County and Michael DeLogg at the Epping farm during 2005 and 2006 was ultimately established through one of the most extensive forensic investigations in New Hampshire history. The evidence recovery process at the LaBarre property involved multiple law enforcement agencies, forensic specialists, and extended periods of careful, methodical site examination. The nature of what investigators were searching for, and what they found, made the process both technically challenging and deeply affecting for the professionals involved. In March of 2006, Epping police responded to the LaBarre property following a tip. What they encountered set the investigation in motion. LaBarre was arrested on March 27, 2006. She was charged in Rockingham County with 2 counts of first-degree homicide in connection with the passings of Kenneth County and Michael DeLogg. The legal proceedings that followed were lengthy and complex. LaBarre's mental competency was evaluated on multiple occasions by qualified forensic mental health professionals. New Hampshire law requires that a defendant be competent to stand trial, that they understand the nature of the proceedings and are able to assist in their own defense. The multiple evaluations in LaBarre's case reflected the genuine complexity of her psychological profile and the care with which New Hampshire courts approached the question of competency. Those evaluations ultimately produced findings that she was competent to proceed. The trial of Sheila LaBarre in Rockingham County Superior Court was among the most significant criminal proceedings in New Hampshire in the first decade of the 21st century. It lasted several weeks. Prosecutors presented forensic evidence gathered from the farm property, testimony from investigators and expert witnesses, and the accounts of individuals with knowledge of LaBarre's conduct and the conditions on the property. The prosecution's case was built on evidence that had been gathered through months of painstaking investigative and forensic work. The defense challenged the state's evidence and offered alternative interpretations of the physical findings. The jury heard all of it, every piece of evidence presented by both sides, every argument advanced by prosecution and defense, and deliberated. On May 10, 2008, the jury returned its verdict in Rockingham County Superior Court. Sheila LaBarre was found guilty on 2 counts of first-degree homicide. The verdict was unanimous. The jury had determined, beyond a reasonable doubt, that LaBarre was responsible for the passings of Kenneth County and Michael DeLogg. At sentencing, Sheila LaBarre received mandatory life imprisonment without the possibility of parole on each count, as required by New Hampshire law for first-degree homicide convictions. She would remain incarcerated for the remainder of her natural life. There was no path to release. There was no mechanism for parole. The sentence was as final as the law allows. The case had a lasting impact on New Hampshire's approach to the protection of vulnerable adults. Advocates for individuals with developmental disabilities pointed to the county case specifically as a demonstration of the gaps that can exist between the reports made by concerned family members and the interventions that result. New Hampshire law enforcement and child and adult protective services agencies engaged in sustained reviews of their protocols in the wake of the LaBarre case, and those reviews informed changes in training and procedure that continue to influence practice today. Kenneth County and Michael DeLogg were young men whose vulnerability was exploited in the most final way. The Rockingham County Superior Court that convicted Sheila LaBarre in 2008, and the jury that delivered that verdict after weeks of testimony and evidence, ensured that their passings were answered with the full weight of New Hampshire's justice system. Sheila LaBarre remains incarcerated. The 2 convictions stand. The record in Rockingham County is permanent. If you found Case 4 important, please like this video. We are grateful for every viewer who stays with us through these documented stories. Case 5, Brittany Barron. Cheshire County Superior Court, State of New Hampshire. September 19, 2020. In the landscape of the American criminal justice system, accountability takes more than one form. There is the direct accountability imposed on those who commit violent acts, the charges, the prosecution, the verdict, and the sentence that follow when investigators establish what happened and who was responsible. And there is a second form of accountability, equally important in the eyes of the law, that attaches to those who witness the consequences of violence and choose concealment over truth. Both forms of accountability exist for important reasons. Both protect the integrity of the system on which communities depend. And in Cheshire County, New Hampshire, in the proceedings that followed the passing of Jonathan Amirault in September of 2020, both forms were applied. Rindge, New Hampshire, is a small town in Cheshire County in the southwestern corner of the state. It is a community of several thousand residents, known for Franklin Pierce University and for the kind of quiet, small-town character that defines much of rural New Hampshire. On September 19, 2020, an event occurred in Rindge that placed the town in the public record of Cheshire County in a manner its residents could not have anticipated. Jonathan Amirault lost his life in Rindge on September 19, 2020. He was a young man with a life that had been interrupted violently, and finally, the investigation into his passing was conducted by the New Hampshire State Police and Cheshire County authorities, and it resulted in the identification and prosecution of the person directly responsible for his passing, Armando Barron. The criminal proceedings against Armando Barron for Jonathan Amirault's passing are a matter of public record in Cheshire County. Brittany Barron was Armando Barron's wife. She was present in the context of the events surrounding Amirault's passing and what she did in the aftermath, according to the charges brought by Cheshire County prosecutors and confirmed by her own subsequent guilty plea, was a series of deliberate acts designed to prevent law enforcement from obtaining the physical evidence it needed to establish what had happened and to hold those responsible to account. 3 counts of falsifying physical evidence were brought against Brittany Barron in Cheshire County Superior Court. Each count reflected a specific act of evidence concealment documented by investigators. Falsifying physical evidence under New Hampshire law, altering, concealing, or removing evidence with the purpose of impairing its availability in an official proceeding, is a felony offense. The law treats it seriously because the consequences of evidence concealment are serious. When evidence is suppressed, truth is delayed. When truth is delayed, families wait longer for answers. When families wait longer for answers, the harm that began with the original act extends forward in time, compounding the injury already done. Brittany Barron pleaded guilty to all 3 counts of falsifying physical evidence in Cheshire County Superior Court. Her guilty plea was not a technicality. It was a formal admission before the court that she had done what the charges alleged, that she had taken deliberate action on 3 separate occasions to prevent investigators from obtaining evidence they needed. The court accepted her plea and imposed a sentence that reflected the seriousness of 3 felony convictions. Jonathan Amaralt's family sought justice not only for the act that ended his life, but for everything that followed. The effort to conceal what had happened to him, the deliberate suppression of physical evidence by someone who knew the truth, was an additional injury to a family already carrying an incomprehensible loss. Cheshire County's prosecution of Brittany Barron was a statement that New Hampshire does not treat obstruction as a private matter between wrongdoers and their consciences. It treats it as a public harm. It brings charges. It seeks convictions. And in this case, it obtained them. Jonathan Amaralt is remembered in Cheshire County. His passing was documented by investigators who worked to ensure that the full truth of September 19, 2020, was placed before the court. The 3 convictions of Brittany Barron for falsifying physical evidence are part of that truth, part of the complete record of what occurred and what followed. The accountability that the New Hampshire criminal justice system applied in Cheshire County to both the direct act and the subsequent concealment is a demonstration of what the system is designed to do at its best: pursue truth completely, hold everyone responsible for their portion of the harm, and ensure that families like Jonathan Amaralt receive the fullest possible answer the law can provide. Please like this video. We are halfway through today's documentary, and every case that follows is as important as the ones you have already heard. Thank you for staying with us. Case 6 is next. Case 6, Pamela Smart. Rockingham County Superior Court, State of New Hampshire. May 1, 1990. Conviction, 1991. There are criminal cases that define an era. There are cases that become reference points not only for the communities in which they occur, but for entire national conversations about the relationship between crime, media, justice, and the lives that intersect with all 3. The case that unfolded in Derry, New Hampshire, beginning on May 1, 1990, is one of those cases. It produced a conviction in Rockingham County Superior Court that has now stood for more than 3 decades. It introduced legal and cultural questions that scholars, journalists, and legal professionals continue to examine. And at its center, beneath all of that, is a verified, documented, permanently recorded truth. Gregory Smart lost his life. A Rockingham County jury determined who was responsible, and that person has been incarcerated in the New Hampshire prison system ever since. Derry, New Hampshire, sits in Rockingham County in the southeastern part of the state. In the spring of 1990, it was a community with no particular expectation of the kind of case that was about to enter its public record. Pamela Smart was 22 years old. She was employed in an educational media role by the school administrative unit serving the Winnacunnet area, a position that gave her regular access to students and the school community. She was married to Gregory Smart, 24 years old, an insurance professional. They had a condominium in Derry. They had careers and the ordinary forward momentum of young adult life. What was not visible in that ordinary exterior was the relationship Pamela Smart had developed with William Flynn, a 15-year-old student. That relationship, its nature and its purpose, was examined in exhaustive detail during the criminal proceedings that followed Gregory Smart's passing. Prosecutors argued, and the jury ultimately accepted, that Smart had cultivated her involvement with Flynn not as an end in itself, but as a means to an end. That end, the prosecution contended, was the elimination of her husband. On the evening of May 1, 1990, William Flynn and 3 other teenagers, Patrick Randall, Vance Latime Jr., and Raymond Fowler, entered the Derry condominium. Gregory Smart was inside. The scene that followed was staged to suggest that a break-in had occurred. Gregory Smart did not survive. He lost his life that evening in his own home. The investigation conducted by the Derry Police Department and the New Hampshire Attorney General's office was methodical and productive. The break that moved the investigation decisively forward came through Cecilia Pierce, a student with knowledge of the events surrounding Gregory Smart's passing. Pierce cooperated with law enforcement and participated in a legally authorized wiretap. The recordings obtained through that process, recordings in which Pamela Smart discussed the events surrounding her husband's passing, were central to the prosecution's case and were admitted at trial following proper legal process. Pamela Smart was arrested and charged in Rockingham County with 3 counts: accomplice to first-degree homicide, conspiracy to commit the same, and witness tampering. The accomplice charge reflected the legal framework applicable when an individual does not personally commit a violent act, but is determined by prosecutors and ultimately by a jury to have directed, enabled, and motivated others to commit it. New Hampshire law is clear that criminal responsibility attaches not only to those who act directly, but to those who orchestrate the actions of others with harmful intent. The trial of Pamela Smart began in Rockingham County Superior Court in Exeter, New Hampshire, in March of 1991. It was one of the first criminal trials in the United States to be broadcast in its entirety on television. Court TV brought the proceedings to a national audience, and the combination of the defendant's age and professional background, the teenage co-defendants, the dramatic wiretap recordings, and the stakes involved made the case a landmark moment in American true crime history. Millions of people followed the proceedings. Legal analysts commented daily on the evidence and arguments. The jury deliberated and returned its verdict. Pamela Smart was found guilty on all 3 counts: accomplice to first-degree homicide, conspiracy, and witness tampering. The verdict was unanimous. Rockingham County Superior Court Judge Douglas Gray imposed the mandatory sentence prescribed by New Hampshire law: life in prison without the possibility of parole. The sentence was imposed in 1991. It has not been reduced, commuted, or modified in any form. Pamela Smart has been incarcerated for more than 30 years. She has appeared before the New Hampshire Parole Board on multiple occasions. Each application for release or reconsideration has been denied. The conviction stands. The sentence stands. The Rockingham County record is clear and permanent. William Flynn and the 3 other teenagers who entered the Derry condominium on May 1, 1990, were prosecuted in separate proceedings. Flynn, who cooperated with the prosecution, received a sentence that included the possibility of parole after a period of imprisonment. The distinction between his sentence and Smart's reflected the legal significance of the difference between the person who physically committed the act and the person the jury determined had directed and enabled it. Gregory Smart's father has been an active voice in New Hampshire criminal justice circles for more than 3 decades, attending hearings and ensuring that the record of what was lost on May 1, 1990, is preserved not as an abstraction but as a human story. The story of a 24-year-old man who should have had decades more of living ahead of him. The Pamela Smart case is a cornerstone of Rockingham County's legal history and of New Hampshire's broader criminal justice record. It is documented completely. It is adjudicated finally. And it stands as a demonstration of the principle that criminal accountability does not require a person to have personally committed an act of violence. It requires only that they intended it, planned it, and set it in motion. Gregory Smart deserved more than 1990 gave him. The Rockingham County Court that convicted Pamela Smart made certain the record reflected that truth. Please like this video and subscribe if you have not already done so. We have 4 more cases, and each one deserves your full attention. Case 7, Caitlin Marin. Hillsborough County Superior Court, State of New Hampshire. Crime dates: between November 24th and November 25th, 2014. Conviction: 2016. Nashua, New Hampshire, is the largest city in the state by population. It anchors Hillsborough County in the southern part of New Hampshire, bordered by Massachusetts and shaped by decades of industrial, commercial, and residential growth that have made it one of New England's most economically significant mid-sized cities. It is a city with a strong municipal infrastructure, an active law enforcement presence, and a Hillsborough County Superior Court that handles the serious felony matters arising from a large and diverse population. In 2016, that court handled a case that the Nashua community, the New Hampshire child welfare system, and the state's criminal justice establishment would not forget. In the final days of November 2014, a 3-year-old girl named Brielle Gage was transported to a Nashua hospital emergency room. She arrived with injuries that the medical professionals who received her recognized immediately as requiring urgent intervention. The nature of those injuries, their severity, and their pattern prompted the emergency medical team to provide everything within their clinical capacity. Despite those efforts, Brielle Gage did not survive. She passed away from the injuries she had sustained, and the investigation that followed her passing was taken up by the Nashua Police Department and Hillsborough County prosecutors. Brielle was 3 years old. She was at that remarkable stage of early childhood defined by the discovery of language, by the exploration of the world immediately around her, by the complete and natural dependence on the adults in her life that is the defining condition of toddlerhood. She had a mother. She had people who were supposed to ensure that every day she experienced was a safe one. She had the right, recognized both morally and in law, to grow up in an environment free from harm. Caitlin Marin was Brielle Gage's mother. The investigation that Nashua police and Hillsborough County prosecutors conducted in the weeks following Brielle's passing produced findings that led directly to Marin. The New Hampshire medical examiner examined Brielle and made determinations regarding the cause and manner of her passing. Those determinations, that her injuries were the result of severe physical harm inflicted by another person, formed the evidentiary foundation on which the criminal case against Caitlin Marin was built. Marin was charged in Hillsborough County with second-degree homicide. The charge reflected the prosecution's legal determination that her conduct in causing the harm that ended Brielle's life was undertaken knowingly, that Marin was aware of what she was doing and of the consequences it would produce. The case was set for trial in Hillsborough County Superior Court. The trial proceeded in 2016. Hillsborough County prosecutors presented the medical examiner's findings to the jury. They presented the testimony of the emergency room professionals who had treated Brielle. They presented the investigative findings of the Nashua Police Department. The evidence placed before the jury described what had happened to a 3-year-old girl in the final days of November 2014, the nature of the harm she had suffered, and the circumstances in which she had sustained it. The defense presented its case and challenged the prosecution's evidence and interpretation of events. The jury heard everything, every piece of evidence offered by both sides, every argument advanced by prosecution and defense, and deliberated. The jury returned its verdict. Caitlin Marin was found guilty of second-degree homicide by the Hillsborough County jury. The verdict was a finding, reached unanimously beyond a reasonable doubt, that Marin had knowingly caused the harm that ended Brielle Gage's life. At sentencing in Hillsborough County Superior Court, the court imposed a substantial prison term consistent with New Hampshire's mandatory sentencing framework for second-degree homicide convictions. The sentence reflected both the severity of the offense and the particular vulnerability of the victim, a 3-year-old child who had no capacity to protect herself and who was entirely dependent on the adult whose conduct the court was sentencing. Brielle Gage's passing prompted renewed attention in Nashua and across New Hampshire to the resources available to families under stress, to the training of medical professionals in identifying and reporting signs of harm to children, and to the coordination between hospitals, child protective services, and law enforcement that is essential to protecting the youngest and most vulnerable members of any community. Child advocates in New Hampshire engaged seriously with the lessons of the Marin case and the question of what systemic improvements might prevent similar tragedies. The Hillsborough County conviction of Caitlin Marin for second-degree homicide in 2016 is a permanent part of the court's public record. Brielle Gage's name is also a permanent part of that record, as the person whose passing prompted the investigation, the prosecution, and the jury's verdict. She was 3 years old. She had barely begun. The Hillsborough County Court that convicted Caitlin Marin ensured that what happened to Brielle did not pass without accountability. Please hit the like button and subscribe to the channel. Every like and every subscription helps us continue bringing documented, verified stories to this platform. Case 8. Jessica Linscott. New Hampshire Superior Court. November 28, 2012. There is a principle embedded in New Hampshire law, and in the laws of every American state, that the duty of a parent toward a child is not satisfied by the absence of personal harmful conduct. A parent's legal and moral obligation extends further than simply refraining from causing direct harm. It encompasses the active, affirmative duty to protect, to see danger and intervene, to recognize when a child in one's care is being harmed and to act, to report, to remove, to do whatever is within one's power to ensure the child's safety. When that affirmative duty is violated, when a parent sees harm coming toward their child and does nothing, or worse, actively prevents the truth from being discovered, New Hampshire law responds with the same machinery of accountability it brings to direct criminal conduct. In November of 2012, a 3-year-old boy in New Hampshire was hospitalized with injuries that emergency medical professionals identified as serious. He had suffered burns and severe physical harm. He was alive. That fact, his survival, matters enormously, and it is a fact that this documentary records with the weight it deserves. He survived because medical professionals responded quickly and because law enforcement acted decisively in the wake of his hospitalization. He was 3 years old, and he lived. The investigation that followed his hospitalization was conducted by New Hampshire law enforcement. What investigators found through that investigation was a household in which the 3-year-old had been subjected to sustained harmful conduct by Roland Dow, the boyfriend of his mother, Jessica Linscott. The investigation established that Dow had been the source of the harm the child had sustained. It also established something about Jessica Linscott, something that the charges brought against her would articulate in the formal language of New Hampshire criminal law. Linscott had been present in the household. She had been aware, or should have been aware, of the conditions her son was being subjected to. And after her son was hospitalized, after law enforcement became involved and the investigation began, she had taken steps that investigators documented and that Hillsborough County prosecutors translated into a second charge. She had not simply failed to protect her son. She had subsequently taken action to prevent investigators from obtaining the full picture of what had happened to him. Jessica Linscott was charged with child endangerment and witness tampering. The child endangerment charge reflected the legal determination that her failure to protect her 3-year-old son from serious harm violated the affirmative duty of care that New Hampshire law imposes on parents. The witness tampering charge reflected the investigative finding that she had taken deliberate action after the fact to impede the investigation into what had occurred. Both charges were serious. Both reflected conduct that the New Hampshire criminal justice system recognized as deserving of formal legal response. Jessica Linscott pleaded guilty to both charges in New Hampshire Superior Court. Her guilty plea was an admission before the court of the conduct alleged. The court accepted her plea and imposed a sentence that addressed both convictions. The guilty plea meant there was no trial, no extended adversarial proceeding in which the evidence would be contested. The facts, as Linscott admitted them, went directly into the court's record. Roland Dow, who had directly caused the injuries sustained by Linscott's son, was prosecuted separately on charges that reflected his direct role in the harm the child had suffered. His prosecution and the charges against him were the subject of their own proceedings in New Hampshire Superior Court. The child at the center of this case was 3 years old. He survived. Those two facts, placed together, represent both the tragedy of what happened and the outcome that the rapid response of medical professionals and law enforcement made possible. He was taken from the harmful environment. The adults responsible for his suffering faced legal accountability. The New Hampshire court system processed both the protective and the punitive response to what had occurred in that household. Child welfare advocates who followed the Linscott case used it as a touchstone in discussions about the complexity of household dynamics in cases involving child harm. The ways in which adult relationships can create environments where the interests of children are subordinated to the interests of adults, and the importance of community awareness, mandatory reporting laws, and robust child protective services in identifying and interrupting those environments before the harm reaches the level documented in this case. Jessica Linscott's convictions for child endangerment and witness tampering are part of the public record of New Hampshire Superior Court. Her son's survival is also part of the record, the most important part, the fact on which everything else is grounded. If you are concerned about a child's safety, please reach out to the Child Help National Child Abuse Hotline at 1-800-422-4453. Trained counselors are available every hour of every day to help. Please like this video. We have 2 more cases to cover, and each one is a story that the public record of New Hampshire compels us to tell. Thank you for being here. Case 9, Hampshire Juma. Hillsborough County Superior Court, State of New Hampshire. Discovery date, March 27, 2025. Arrest date, February 26, 2026. Manchester is New Hampshire's largest city. It sits in Hillsborough County and carries the particular character of a post-industrial New England city that has reinvented itself over decades, a city with a complex economic history, a diverse and growing population, and the full range of civic institutions that a large urban municipality requires. Its law enforcement infrastructure, centered on the Manchester Police Department and supported by the New Hampshire Attorney General's Office and the Hillsborough County Attorney's Office, handles the full spectrum of criminal matters that arise in a city of its size. In March of 2025, that infrastructure was called upon to respond to a discovery in Pine Island Pond that would launch one of the most sustained and emotionally significant investigations the city had seen in years. On March 27, 2025, law enforcement responded to Pine Island Pond in Manchester. What they found there was the body of an infant, a newborn girl. She had no name in the official record at the time of her discovery. She had no identification. She was known, in the language of law enforcement and forensic documentation, as Baby Jane Doe. She was, in the language of common humanity, a child who had barely entered the world before she left it. The Manchester Police Department, working in close coordination with the New Hampshire Attorney General's Office and the New Hampshire Medical Examiner's Office, took charge of the investigation. The medical examiner examined the infant's remains and made findings regarding the circumstances of her passing. Those findings informed the investigative direction that law enforcement would pursue over the months that followed. They also informed the decision, made later by Hillsborough County prosecutors, to pursue homicide charges when a suspect was identified. The infant was given the name Grace by the investigators and community members who worked her case and who understood, in the way that professionals who encounter the most difficult aspects of their work often do, that a life, however brief, deserves acknowledgement. Baby Grace. The name became part of the public discourse around the case in Manchester and in New Hampshire more broadly. Vigils were held. Community members who did not know the child and had no connection to the circumstances of her passing came together in the recognition that a life had ended before it could begin, and that the response to that fact had to be as complete as the law could make it. The investigation was technically demanding. Identifying the infant, establishing the circumstances of her passing, connecting those circumstances to a specific individual. All of it required forensic work of a kind that extends well beyond the immediate evidence available at a scene. DNA analysis, medical records examination, and sustained investigative inquiry were central to the process. The work took months. The Manchester Police Department and the New Hampshire Attorney General's Office remained committed to it throughout. On February 26, 2026, New Hampshire law enforcement arrested Hampshire Juma. She was charged in Hillsborough County with reckless second-degree homicide. The specific statutory language of the charge carries significant legal weight. Reckless second-degree homicide with extreme indifference to the value of human life. The framing used by Hillsborough County prosecutors places the alleged conduct in the most serious category of reckless criminal conduct recognized by New Hampshire law. It reflects a prosecutorial determination that the circumstances of the infant's passing involved not mere carelessness or accident, but a level of disregard for life that the law treats with the gravity reserved for knowing and intentional acts. The arrest of Hampshire Juma was reported by Boston.com, Manchester Inc. Link, and other established news organizations covering New Hampshire. The Hillsborough County Attorney's Office confirmed the charges. At the time this documentary was produced, the case was proceeding through Hillsborough County Superior Court. As with all pending criminal matters, Hampshire Juma is presumed innocent unless and until the state of New Hampshire establishes her guilt beyond a reasonable doubt before a jury of her peers or through a court-accepted guilty plea. This documentary presents the verified facts of the case as established by the official public record. What the public record confirms, independent of the outcome of the criminal proceedings, is a complete arc of institutional response. A newborn infant was found in Pine Island Pond on March 27, 2025. Her passing was investigated with the full resources of Manchester's law enforcement community and the New Hampshire Attorney General's office. A name, Grace, was given to her so that she would not be forgotten. And nearly a year after her discovery, the Hillsborough County Attorney's Office filed charges that placed the question of accountability for her passing before a New Hampshire court. Nearly a full year of investigative work. DNA forensics, medical examination, sustained inquiry. All of it in service of a child who had no name when she was found, who had been given one by the people who worked to find the truth of what happened to her, and whose passing the New Hampshire criminal justice system refused to allow to go unanswered. Baby Grace deserved the world. She deserved the years that should have followed her birth. The investigation that led from Pine Island Pond to the Hillsborough County Courthouse was New Hampshire's answer. Imperfect, because no legal outcome can fully answer the loss of a life before it begins, but complete in the sense that counts. Thorough, committed, and unrelenting in its pursuit of the truth. If you or someone you know has information about harm to a child, please contact local law enforcement or the Child Help National Child Abuse Hotline at 1-800-422-4453. Please like this video. We are almost at the conclusion of today's documentary, and Case 10 is one of the most documented and consequential criminal cases in New Hampshire's entire history. Stay with us. Case 10, Julia Byrne. Merrimack County, State of New Hampshire. Crime date, May 10, 2025. Pembroke, New Hampshire, is a small town in Merrimack County situated just south of Concord, the state capital. It is a quiet community, the kind of place where residential streets are familiar, where neighbors recognize each other, and where the arrival of law enforcement in significant numbers is an event that marks itself in community memory permanently. Pembroke sits on the Merrimack River, its landscape shaped by the water and the fields and the wooded hillsides that characterize central New Hampshire's geography. It is the kind of place where people move to find the quiet and the safety that small-town New England life has always promised. On May 10, 2025, Merrimack County authorities responded to a residence in Pembroke, and what they found when they arrived set in motion an investigation that would produce findings now preserved in the permanent official record of Merrimack County and the state of New Hampshire. The response to the Pembroke residence on May 10 involved the Merrimack County Sheriff's Office, the New Hampshire State Police, and the New Hampshire Attorney General's Office. The involvement of the Attorney General's Office, which provides coordination and oversight for major crime investigations statewide, signaled from the outset that what had been found at the residence was of the most serious kind. The investigation that followed engaged every layer of New Hampshire's law enforcement infrastructure that such cases require and proceeded with the methodical thoroughness that serious homicide investigations demand. Inside the home, investigators found Julia Byrne and her 3-year-old son, Blake Byrne. Both had sustained fatal gunshot wounds. Neither had survived. The New Hampshire medical examiner was called to the scene and subsequently examined both individuals. The examination was thorough and the findings were documented with the precision that the New Hampshire Medical Examiner's Office brings to every case under its jurisdiction. The results of that examination were clear. Blake Byrne's passing was ruled a homicide. He was 3 years old. The official determination by the New Hampshire Medical Examiner that his passing was a homicide means, in the precise language of forensic medicine and New Hampshire law, that his life ended as the direct result of an act committed by another person and that his passing was neither accidental nor the result of natural causes. That determination, made by a qualified forensic professional, documented in an official report, and confirmed by Merrimack County law enforcement, is the most consequential fact in the official record of what occurred in Pembroke on May 10, 2025. Julia Byrne's passing was ruled a suicide. Merrimack County authorities, in coordination with the New Hampshire Attorney General's Office, officially classified the incident as a murder-suicide, a classification with a specific and recognized meaning in both law enforcement practice and forensic investigation. It is a classification made only after thorough examination of the physical evidence, the forensic findings, and the full range of investigative materials available to the responding agencies. The decision to apply that classification is not made lightly, and in this case, it was made after a complete review of everything the investigation had produced. Blake Byrne was 3 years old. He was at the age when children are learning to run with confidence, to speak in full sentences, to understand jokes, to form the early friendships that shape a child's understanding of the world beyond the home. He was entirely dependent on the adults around him. He had every reason to expect, as every 3-year-old has every reason to expect, that the people responsible for his safety would provide it. The ordinary, foundational expectation of a child his age, that the home he lived in was safe, that the adults in his life would protect him, was not met on May 10, 2025. He was in his home, and he did not survive the day. Because Julia Byrne did not survive, the legal mechanisms that follow when a person accused of a crime is living, the arrest, the charges, the grand jury, the indictment, the trial, did not engage. There was no courtroom. There was no verdict from a jury. There was, instead, the thorough and professional work of Merrimack County investigators, the medical examiner's determinations, and the official classification of the incident by New Hampshire law enforcement. A classification that places the full truth of May 10, 2025, into the permanent public record and ensures that what happened in Pembroke is documented in a form that will not be lost. The Associated Press and MER reported on the Pembroke case in the period following May 10, drawing on official law enforcement statements and the findings of the New Hampshire medical examiner. Those reports, grounded in official documentation, established the public record of what had occurred. That public record identifies Blake Byrne as a 3-year-old child whose passing was a homicide. It identifies Julia Byrne as the individual whose actions, in the determination of New Hampshire law enforcement and the medical examiner, led to both deaths. It is a record that is clear, documented, and permanent. The community of Pembroke responded to the events of May 10th with the grief and the communal reckoning that events of this magnitude produce in small communities. Neighbors who had known the Byrne family processed the news with the disorientation that always accompanies the discovery that a tragedy has occurred quietly, out of sight, behind the closed door of a house that from the outside gave no indication of what was happening inside. The broader New Hampshire community, through the reporting of established news organizations, was also brought into that reckoning, into the shared acknowledgement that a 3-year-old boy in Merrimack County had lost his life, and that the official record of New Hampshire would preserve that truth. The events of May 10, 2025, in Pembroke are part of a broader and deeply difficult set of questions that researchers, mental health professionals, and law enforcement agencies across the country continue to wrestle with. The question of how to identify individuals in crisis before tragedy occurs, how to ensure that mental health resources reach the people who need them, and how communities can create the conditions under which people experiencing severe distress feel able to seek help. These are questions that do not have simple answers. They are questions that every familicide case, every murder-suicide that ends with the passing of a child, forces back into the public conversation with renewed urgency. What is not subject to those questions, what is fixed and permanent in the official record, is Blake. 3 years old. His passing ruled a homicide. His life recorded and acknowledged. His name part of the Merrimack County record not as an abstraction, but as a child who was real, who existed, and who deserved every year that May 10, 2025, denied him. Merrimack County authorities and the New Hampshire Attorney General's office conducted their investigation with the professionalism and thoroughness that Blake Byrne's passing demanded. The truth of what happened to him in Pembroke is documented. It is preserved. It will not be forgotten. And this documentary, Cold Case Hour's record of 10 cases from New Hampshire that the public record demands be told, ensures that Blake's name reaches an audience beyond the official case file, beyond the newspaper reports, and into the ongoing conversation about what communities owe to their most vulnerable members. Blake Byrne was 3 years old. This documentary says his name so that the record is complete and so that he is remembered. 10 cases. Rockingham County, Hillsborough County, Strafford County, Cheshire County, Merrimack County. 10 sets of victims whose stories belong to the public record of the state of New Hampshire and to the memory of the communities that witnessed what happened when the people responsible for protecting them chose otherwise. The New Hampshire criminal justice system, its investigators, its medical examiners, its prosecutors, its judges, and its juries, responded to each of these cases with the commitment the victims deserved. Not perfectly, not without lessons still being absorbed, but with the sustained, serious engagement that the law demands, and that the people at the center of these stories had every right to receive. Elijah Lewis, Brielle Gage, Gregory Smart, Kenneth County, Michael DeLog, Jonathan Amaralt, Janet Rishjiel Kelson, Ryan Long, Parker Long, Ryan Long Jr., Blake Byrne, Baby Grace. These names are not case numbers. They are not statistics. They are people. People who existed, who mattered, and whose passing demanded the full attention of the system New Hampshire built to answer for exactly this kind of harm. This documentary exists to ensure that attention is paid, that the record is accessible, and that none of these individuals fades into the background noise of a news cycle that moves faster than memory. Cold Case Hour is committed to responsible, verified, court record-based true crime documentary content. Every case covered on this channel is confirmed through established news sources and public court records. Every story is told with the accuracy and the respect that victims and the historical record deserve. If this documentary has informed you, if it has honored the people at its center, if it has given you a clearer picture of the New Hampshire criminal justice system's response to the cases that tested it most severely, please take 30 seconds right now and do 3 things. Hit the like button. It signals to the platform that this content is valuable and helps other viewers who need to hear these stories find their way to this channel. Leave a comment below. Tell us which case stayed with you. Tell us what you think. Your comments are the direct line between this channel and the audience that keeps it alive. And hit the notification bell. Every new subscriber is a commitment to making sure these stories reach the widest possible audience. Every notification bell ensures you will be here for the next documentary. Thank you for watching. Thank you for staying through 10 cases, 10 counties, and 10 stories that New Hampshire's courts and communities will carry for years to come. The record matters. The names matter. We will see you in the next case.